Pleasure to introduce Mr. Garv Malhotra, a distinguished lawyer who has been involved in some market-moving mandates and jurisprudence-shaping cases lately. Mr. Malhotra is a partner at Skywards Law. He has had an illustrious career spanning many jurisdictions and has studied, practiced, and taught law around the world. In addition to being a full-time practitioner and leader of one of the leading boutique firms, he dabbles as an academic. Last year, he was appointed as the youngest honorary professor of law at NLU Delhi, where he teaches international business law and arbitration. He is a graduate of prestigious institutions in India, Singapore, Switzerland, France, and Netherlands. He is also a member of India Committee of the American Arbitration Association and one of the organizers of Delhi Arbitration Weekend. I can go on and on about his educational background, his experiences, his initiatives, and his profile, but that would take a while. I can, however, tell you on a personal note that he has invited us to donate the honorarium of this session to the Wildlife SOS charity. So, without any further ado, I hand over the platform to Mr. Garv Malhotra. Over to you, sir. Sir, you're on
Hi.
mute. Right.
Yes. Hi. Good afternoon, ladies and gentlemen. It's good to be here. Thank you for that lovely introduction and for the opportunity to deliver a lecture on the topic of international business law. It is wonderful to see so many people joining this session on a Saturday afternoon. So thank you all for logging into this session. As you are now aware, I am a lawyer. I practice international commercial law in its various forms. I end up getting the chance to work on some pretty exciting transactions and disputes on a day-to-day basis, and that often involves the laws of multiple countries. I also teach law at NLU Delhi, and today we are going to talk about a very interesting topic, international business law. Now, before I go deeper into the subject, I do want to let you know that there are some house rules for my class. My name is Garv, so please address me by my first name. I really prefer being addressed by my first name and not as sir, including you, Madam Moderator. Second, this whole lecture is being conducted to better your understanding of this subject. So at any point of time, if you have any doubt, please do not wait till the end. Just interrupt me and ask a question. You may just ask me to repeat something or clarify something, or feel free to take me on a tangent and ask a hypothetical question. There is no concept of a silly question in this class, so please do not hesitate to ask me any questions. And third, Madam Moderator, the moment I need to move to the next slide, I will tell you. So please move to the next slide.
Right, sir.
Okay, we are here to talk about international business law. So in business speak, let's set the agenda for today's class. We will start with a very simple introduction to what is international business law, what does it entail. We'll then move on to discuss the sources of both international law and, more importantly for this topic, the sources of international business law in modern trade and commerce. We will then move on to discuss a few types of cross-border transactions, and then we will discuss the various laws that could apply in such transactions. And finally, we will talk about managing international contracts, planning for international transactions, as well as resolving a dispute in case a dispute does arise in international transactions. So at any point of time, feel free to just pause and ask me a question, and I'd be happy to clarify anything. Okay, next slide, please. So, what is international business law? It is one of the greatest myths that have been created by humanity. And this myth has been created to ease commerce. I say it is a myth in the sense that it is a creation of fiction, legal fiction. International business law is an artificial construct based on the foundation of legal fiction. And the commercial world is full of such legal fictions. For instance, a company. Now, okay, it's an artificial construct, but international business law is a form of law, right? Before we answer that, we need to think, what is law? When we think of law, we generally think of rules which would govern the conduct of individuals and entities and which are enforced by a sovereign. These are guidelines that people and entities are obliged to follow. And otherwise, if they do not follow that, there will be repercussions from some authority. Let's take an example of simple laws like you cannot shoot your neighbor or you cannot steal somebody's property. And if you do, the law of the land will punish you and by enforcing their own laws. In the 1800s, an English philosopher, John Austin, he had called this command of the sovereign, that law is the command of a sovereign power issuing guidelines and enforcing compliance with those obligations. However, if you think about it in the international context, there is no singular sovereign or overarching authority over humanity, right? There is no single legislature which is publishing codes of conduct or monitoring compliance with rules or handing out punishments for deviation. Every country exercises sovereignty over its territory and its people. And so when individuals from various countries and entities from different countries interact with each other in a commercial transaction, what laws apply? The answer, which is usually the correct answer and the shortest answer in most legal situations, is it depends. And let's see what it depends on and what are the main criteria and main elements that together form international business law. Slide, please. International business law is not a single code published by a single body. Instead, it refers to a full ecosystem of laws that apply by default to a cross-border transaction, as well as modular systems which we can selectively choose and apply to a transaction so that only a given set of laws apply and not other laws apply to the transaction. Now, this concept, which is a fluid concept, a dynamic concept, will take a little time to understand, so please bear with me. International business law comprises of a gamut of various laws, regulations, including national laws, including international law. And when we talk about international law, we usually talk about public international law, that is the law that governs the relationship between two states or two or more states. We can take examples, for instance, UNCLOS, the United Nations Convention on Law of Seas. That is a part of international law because it is an international convention that governs the relationship between various countries in the high seas. But international business law cannot exactly be the same. Let's look at what are the sources of public international law as a starting point to understand what comprises international business law in general. Next slide, please. Now, according to the Statute of the International Court of Justice, there are 4 key sources of international law. And I reiterate, we are talking about public international law here and not international business law just yet. So what are these sources? First are international conventions. Conventions, treaties, covenants, by whatever name they may be called, they are codified obligations between countries and parties, country parties inter se, and these are binding upon countries if signed properly and ratified in accordance to their national laws. We have international customary principles which are built of opinio juri and state practice over a period of time and which are treated as obligatory by states in their conduct over a prolonged period of time. We have general principles of law, just general principles that are accepted across the world. For instance, the principle of res judicata. It is a principle that is commonly accepted in various countries of the world, that a matter which has been finally adjudicated and settled should not be allowed to be reopened. And then you have judicial teachings, judicial decisions and teachings. Judicial decisions, that means decisions of various courts and tribunals across the world, both at a national level and at an international level. And teachings of highly qualified authors and publicists, people who have dedicated decades to research experience and then written about them, and you know which comprise of authoritative sources of opinions on international law. These are all considered sources of international law, but these are not exhaustive. These are just the main sources of international law. And if we think about it, all of these sources in the current format have been codified and crystallized into these obligations only in the 1940s. After 1945, World War II, the UN institutions, when they were created after the 1944 Bretton Woods Conference, which established institutions like United Nations, IMF, World Bank, together in those situations, in 1945, this idea was created that international law comprises of these four key sources. But international business law cannot be exactly the same, because humans have been engaging in trading activities with individuals from other countries since ancient times. This is 1945, but humans have been conducting international trade since a very, very long time. And thus, the origins of international business law have to predate the concept of even sovereign states as we know them today. Next slide, please. So, how does international trade in the ancient times work? If we think about it, international trade, dates back and was developed in some prominent hubs like Greece, the Silk Road, ports in Europe, and among others. The Silk Route was the first major trade route that connected the East and the West, and this was an important trade route for over 2000 years, connecting Asia with Europe via the Middle East. Even if we look at Africa, Egyptians, Europe, Greeks, they had extensive commercial exchanges through sea transport over the Mediterranean Sea. And these trade relations in ancient times established the first unwritten customs and rules of maritime transport. Maritime ordinances, unwritten customs were also popular in other major port cities: Arles, Hamburg, Istanbul, Genoa, Venice, Barcelona, and so many others. Now, this means that since ancient times, there have been certain principles, customary principles, that have been accepted by the overall merchant community. If we take an example of, let's say, a Scandinavian Viking ship docking in modern day Istanbul, Constantinople at the time, and buying fur carpets from Istanbul to, to take back to their own country. Obviously, they would be governed by the laws of the Byzantine Empire, which was the land that they were buying the goods in. But in terms of maritime transit, in terms of overall commerce, they were also governed by a series of mercantile customs which had developed over centuries. And these mercantile customs, which were treated as obligatory by merchants, which were treated as binding, while these were unwritten codes of conduct, unwritten customs, but these were treated as binding by transacting merchants since ancient times. That is called lex mercatoria or law of merchants. Now, in modern times, most of the rules and customs that comprised of the body of laws known as lex mercatoria have been superseded by a clear set of laws which are often codified in the form of legislations. And thus, lex mercatoria in the 21st century has much less significance than it did 400 years ago. However, lex mercatoria still acts as an aid to interpretation and can do a gap filling function. Some of these principles have also been codified in the form of what is known as the UNIDROIT principles or UNIDROIT. Uni means unified, droit is the French word for law, and these UNIDROIT principles on international commercial contracts are principles of law which are generally considered a codification of the ancient law of lex mercatoria. Now, lex mercatoria has always been a vague and fluid body of law. It differs from region to region, from industry to industry. Cotton merchants will have a different understanding of what is mercantile customs from that of fur traders or shipbuilders, and so on and so forth. And therefore, lex mercatoria has always been difficult to pin down that this exactly is lex mercatoria. I hope you're all following. Please don't hesitate to stop me if you're not. Okay, so let's use this and segue onto the next part, which talks about what does modern international business law contain. It can't be just lex mercatoria, and it cannot be public international law. So what does modern lex mercatoria entail? Okay, just a second. We have a
Ji, sorry for the interruption. Will you provide these materials, or we have to take note? Your lecturer, will you provide these synopses?
sure. Certainly, I can provide these principles.
Thank you,
Uh,
thank you. Then we
I-
can concentrate your lecturer. Yes.
yeah. So I've also mentioned that in the chat box. These are called the UNIDROIT, DROIT, which is a French word. It's written as droit in English, but it's pronounced properly as UNIDROIT. And the body that maintains is United Nations. It is a United Nations endeavor which has created the UNIDROIT principles. And I'll happily share a copy of these principles after the class. Now, UNIDROIT principles are just one form of non-binding codification of ancient customary principles. But what is modern international business law, which is the topic of this conversation? What is the law that applies when in modern day and age we are entering into transactions with people from a different country, with companies, with entities from beyond our own borders of a sovereign state. Can we move to the next slide, please? And I have distilled this myself and created this diagram for a better understanding. Today, international business law has three key sources. Now, I don't say that these are the only sources. This is not an exhaustive list, but these are the three key sources. You see national laws. That means if, let's say, there are parties of two countries engaging in a transaction, so the national laws of both of those countries. We have international law and rules. We saw some sources of international law. There are a few other instruments in international law, which are private instruments or instruments which have not attained the status of consensus across the world, but in certain sectors are widely regarded. Could be a regional convention. And then we also have Lex Mercatoria. And when we put all of these together, it is referred to as international business law or the law of international commerce or cross-border law, which is the entire gamut of laws under a common umbrella which apply in an international transaction. So what national laws would apply? For instance, the Contract Act and the Sale of Goods Act would govern various parts of a transaction, which are national laws. International laws, for instance, we have the SIAC, which we will see in a bit, and we will also have, various regulations like the WTO regulations. We will also have Lex Mercatoria, a national law, as it's called, which is UNIDROIT principles, for instance. Now, Lex Mercatoria in the modern day and age is a national, which means that it is not connected to a particular country. It's not that the Lex Mercatoria of Japan differs significantly from the Lex Mercatoria of Burkina Faso. Essentially, Lex Mercatoria is a general body of law and vague set of principles that are applied in an international transaction. So now that we have an idea of the fact that international business law is not a single code, but a bunch of different laws which are put under a common umbrella of international business laws, let us look at this from a more practical perspective. Let's look at specific examples of cross-border transactions and see how various facets of international business law can apply there. Can we move to the next slide, please?
Sir, I think you're on mute.
The next slide after this, please. Yes. So these are some common examples of cross-border transactions. It could be a sales contract, like I agreed to sell 1 million candles from India to Saudi Arabia. And so essentially there is a seller in one country and a buyer in another country, and the goods are usually being carried by a vessel like a ship or an airplane from country A to country B. That's a sales contract. It could be for sale of any type of good or service. We have joint ventures, companies from two different countries collaborating in an organized fashion to undertake a project in a third country. Let's say a company incorporated in India and a company incorporated in Singapore, together agreeing to develop a dam in Malaysia. We could have licensing or distribution agreements, which are agreements whereby rights to property held by one company are provided to another in various formats. It could just be the rights to distribute a product, like the right to distribute an iPhone or Apple products in a particular country or in a particular territory. Or it could be the rights to a software, the right to use a software on a license basis, which is created in one country but being used in another country. We could have investment agreements. We see progressively in the last 50 years more and more cross-border investment agreements where capital or money from one country is being invested across borders into the territory of another country. And we could also have technology transfer or data transfer agreements whereby, let's say, the data of Indian nationals is being transferred to a specific territory which is permitted under the Indian regime. So, in those situations, what laws will possibly apply? This is just a general set of examples, and let's generally talk about various kinds of laws that could apply in such situations. The next slide, please. So obviously, we can have the commercial laws of multiple countries apply, like the contract law, the sale of goods law, the consumer law, and the customs law. If you are transferring data of Indian nationals, Indian individuals from India to Singapore to United States, in those situations, the data privacy laws that give protections to Indian nationals will have to be complied with. If you are selling goods, you do have to comply with the custom laws of both countries, both from where you're sending it and in the country that you're receiving it. You may have various custom schedules of the WTO applicable, or you may be subject to duties under the WTO regime, which is its own set of laws. You could have the advantage or the disadvantage of treaties like bilateral investment treaties or double taxation avoidance agreements. For instance, somebody is investing significant amounts in Dubai and would possibly have the advantages of the India-Dubai investment treaties as well as the double taxation avoidance agreement, so that you're not paying tax at both places. The objective of this example is to further demonstrate that in any given transaction, a wide variety of laws can apply. But that's at the transaction stage. What happens in case there is a dispute? In case parties, after entering into a contract, are disagreeing significantly on a point and have no option but to have it resolved through a dispute resolution mechanism, well, then you have other procedural rules of an international character that can come into play, like the Singapore International Arbitration Center rules. These all, in some ways and forms, form a part of international business law. So it's always very hard to pinpoint or for experts to agree on a singular definition of what constitutes international business law. And most experts will clearly say that international business law is just the sum total of all the laws that apply in an international transaction situation. Now, this leads to a lot of confusion. You see, if I'm selling to a different country, will my law apply? Will their law apply? On a given point of question, to see a buyer's duty to check the goods before accepting them. In India, you may consider, okay, this is necessary. The buyer, if he's accepted the goods, he should have checked, and he can't raise a claim belatedly after 6 months saying, no, the goods you sold me 6 months ago, they were terrible. I'm not going to pay. You return the money back. In such a situation, what law will you apply? And this was giving rise to a lot of confusion and ambiguity in international contracts. So, in one of the measures that UN undertook in the 1980s, it came up with a convention which is designed to codify obligations on a substantive law level, not procedural law, not dispute resolution, but simply a common unified substantive law for sale of goods, for instance. Um, can we have the next slide? And this is what is called the CISG, or the United Nations Convention on Contracts for International Sale of Goods. Now, as the name suggests, CISG specifically refers to contracts for sale of goods and services. And the CISG, which came into force in 1988, is one of the key instruments which works in a very interesting way. It applies the CISG, which is comprised of articles which are similar to contract laws of countries. Let's say, this is how an offer is given, this is how acceptance happens, and it's a unified, harmonized format. This applies if both parties are located in a state where their respective home countries have signed and ratified the CISG convention. So CISG essentially is a country-to-country convention at the public international law level, which gives the advantages to the subjects of those respective states. So if a person in a particular country whose country has signed and ratified CISG contracts with a person of another country who's in a similar situation that their own country has signed and ratified the CISG convention, in those cases, the default rule, and in the absence of any other clear indication in their contract, the default rule becomes that the governing law of the contract primarily becomes CISG. Now, CISG has established some clear guidelines for formation of international sales contracts, offer, acceptance, but it also gives value to the concept of lex mercatoria, as we just discussed. In fact, Article 9.1 of the CISG states that the parties are bound by any usage to which they have agreed and by any practice which they have established between themselves, unquote. So, both usages and practices that have been established between the parties are also considered within the CISC. So it applies by default if both parties come from countries whose countries have signed and ratified the CISG convention. And currently in the world, there are about 97 countries who have signed and ratified the CISG convention. Notably, India has not signed the CISG convention. So when an Indian national or an Indian company is entering into a contract with, let's say, a German company, in that case, CISG does not apply by default. You can, of course, agree in your contract that we will govern this law by CISG, and that is your choice. But as a default rule, CISG only applies if both parties come from countries which have signed and ratified the CISG convention. Next slide, please, so that we can take an example. Can we have next slide, please? Yeah. So let's take an example. Let's only look at the first part and not the second part at the moment. If there is a company, Camigliano, it's a manufacturer based in Italy, and it enters into a contract to sell ready-made Italian suits to another company, Donatello, which is a retailer based in Brazil. Now, Brazil and Italy are both signatories to the CISG convention. And so in that case, in case their contract doesn't mention anything else, by default, their contract for sale and purchase will be governed by CISC. However, not all contracts between parties of CISG signatory countries are in practice governed by CISC, because very often you end up seeing a clause similar to what is at item 2 here, where you mention governing law and say that contracting states will be governed by, let's say, Portuguese law, as an example here. And it includes a clause clearly saying that CISG shall not apply. So parties, even when both are from countries which are signatories to the CIG convention, can easily exclude the application of CISG by putting a clause to that effect and choose a neutral law. Here in this case, it appears Camiliano and Donatello have chosen Portuguese law. Portuguese law is a civil law based continental law, which is in some ways similar to Italian law. So the Italians would be comfortable with it. And Brazil was a former Portuguese colony. So they also have some legal traditions which overlap with Portuguese law. So as a middle ground, parties could choose a third law, a neutral law, as an option to govern their contracts. Now, this is all good and fine, but the more we start to understand what international business law is doing, it just gives the impression that it's very confusing. At any given point, what law will apply, what law can apply, these are all very nuanced questions which appear to require detailed computations and formulas. So, in modern practice, we do not end up using default systems as much. Instead, what we use is a well thought out approach, and which can be called like a modular system. Can we have the next slide? And that is usually considered a very efficient approach, both between CISG signatory country parties, as well as with the other half of the world, which is not a signatory to the CISG. CISG has been criticized on a lot of counts for various issues, and it has received much more of a recognition in the civil law world than in the common law world. And wherever there is a transaction between a party, let's say a party who's not a signatory to CISG, a common law country like India, getting into a contract with any foreign entity, the most efficient approach usually is to design your own modular system of laws that apply to an international transaction based on ex ante consent, which exclude the application of vague default principles and gives clarity on obligation and forum in the event of a dispute. Let me explain this further. When you are entering into contracts, you have the option of designing your own DIY system of laws which will apply to the transaction you are entering into. Now, of course, some laws will apply by default, but the most of the laws that apply to a particular transaction can be chosen by parties inter se. Like we saw the example in the previous slide of Camiliano and Donatello, where they have themselves chosen Portuguese law to apply, a neutral ground. In addition, they could also choose that, in the event that we still have a dispute later on, 2 years into the transaction, it should not be that the Italian company is litigating the dispute in Brazilian courts and the Brazilian company is facing a similar situation in Italian courts. Instead, how about we choose a neutral venue, a neutral court, or arbitration, which is the most commonly used efficient form of international dispute resolution mechanism. We will speak a little bit more about international arbitration towards the end, But right now, the broad point that I wish that you all take away from this is that the the correct approach is to foresee what will possibly happen in a transaction, how to avoid conflicts, and in the event that there is a conflict, you should have an efficient mechanism already built into your contracts. These could be sales contracts, investment contracts, any other type of technology transfer or other cross-border contracts. You should already have such clauses which give clarity and alleviate ambiguity, because otherwise at a later stage you will end up feeling very confused. Now, as lawyers, it's very easy to say that you should have your contracts very clear and no ambiguity, but very often these contracts are negotiated between commercial parties who do not have a detailed understanding of this concept. um, and so you see the absence of some of these clauses, which, if were put, would give a lot of clarity. But the absence of these clauses can end up losing companies a lot of time, effort, energy, and money. So now, if we can move to the next slide, let's take an example of joint venture agreements. An international joint venture agreement, if let's say it's between a Swiss hotelier and a Maldivian government uh, to create hotels. It's a government entity and a private entity joint venture partnership. The government of Maldives would never want to go to Swiss courts, and the Swiss investor into Maldives won't want to invest large sums of money in collaboration with the government there, and then find itself in a situation that the government has changed and the new government is throwing them out. And even if they have to fight a dispute, it is as per Maldivian law and in Maldives courts, because that may give rise to a very genuine apprehension of bias, both in terms of law and legal culture and in terms of courts. And so, a very common thing that you would see in such contracts is a governing law which designates, let's say, English law, that the laws of United Kingdom will apply to this transaction, and a clear jurisdiction clause that in the event of a dispute between the parties, we will resolve the dispute in accordance with uh, the Singapore International Arbitration Center rules or the London Court of International Arbitration LCIA rules. So, in such a contract between party from country A, party from country B, they have collectively at an ex ante stage, which means at the stage of entering into the contract, already agreed that, in case we need to interpret this contract, we will not interpret it as the Swiss interpret it or as the Maldivians interpret it. We will interpret it as per a neutral benchmark, like how the British interpret it. And in the event that we have a dispute, we'll just go to a neutral arbitrator appointed by the London Court of International Arbitration and resolve all our disputes in front of that arbitrator. Now, there could be other possible avenues in such a situation, because while this is a contract between a private company and a state-owned entity, that is like something like a public sector enterprise of the Maldivian government, in some ways, it could also possibly give rise to a bilateral treaty claim, whereby, let's say, there is a treaty between Maldives and Switzerland. By virtue of the investor who's investing large sums of capital from Switzerland into Maldives to set up hotels, they may also have the advantage of certain other treaties like the bilateral investment treaty, free trade agreements, and so on and so forth in those particular jurisdictions. But that's at a different level. That's at a investment law level. At a commercial contract level, it is usually the best approach is to preempt and design your contract such that you have already foreseen issues that may arise and interpretations that may be required, and designate a clear governing law and a clear jurisdiction. Let's look at the next type of contracts, which we see very often internationally. Can we have the next slide? Can we have the next slide, please? I think I usually prefer to switch my slides myself. We are here now talking about sea carriage contracts. Very simple contract for carriage of goods by sea. If you are, let's say, producing 1,000,000 tons of coal in one country, and you are selling it to a buyer in a different country, it's very hard to fly the coal there. It's very expensive. Coal is a heavy commodity. It's something that in the most efficient way of transporting goods in modern times very often ends up being carriage of goods by sea. These are large vessels with containers. I'm sure you've seen pictures of such vessels, massive vessels larger than football fields, which contain standardized uh, standardized containers and which have capacity to transport a large amount of goods from one country to another through a network of ports that connect the whole world. Now, in such a situation, very often, you have contracts with a third party. If I'm selling goods to a buyer in Japan, the goods are going from a ship, and that ship, which is, registered in a particular country, it's owned by people of a particular country, that gives another legal element to it. What happens if that ship, runs into some trouble, runs into some weather issues, that ship sinks, God forbid? What happens to that? Is that something that would be governed by Indian law or Japanese law, or would it be governed by the agreement that the buyer and the seller had to apply a third law? You can have that contract with the buyer and seller, but this is a third party who is just taking goods from point A via the few international waterways and high seas, and just providing the goods in a different country. So these contracts usually are called charter party contracts, whereby you charter either a full vessel or certain space in these vessels to transport goods from point A to point B. And it is also one of those things that should ideally be agreed to in the contract. You have various types of contracts, FOB contracts, CI contracts, where essentially you have the buyer and seller agreeing that on who is the liability to engage the charterer of the vessel, to engage the party who will take it from one port to another port. And this is a very common transaction that we see on a regular basis in most international sale of goods contracts. Now, charter party contracts are very often governed by other sets of laws, and these are separate contractual relations. So usually either the buyer or the seller has the responsibility for charter party contract, for engaging the charterer, and this is a separate contract between, let's say, the seller who's selling as well as the charterer.
Sir, you're on mute.
Yeah. So charter party contracts, in our experience, very often are governed by laws like English laws or Singapore laws, Because these countries over the years have built a very strong jurisprudence of international maritime law. These countries have a very robust ecosystem around maritime transport, including underwriters, insurers, including customs agents, and a wide variety of various intermediaries that are necessary in these transactions. So, charter party contracts, which are again international in their character, similarly have a designation of the fact that these contracts will be governed by laws of X country, and in case of a dispute, um, we will go to arbitration in country Y. We will circle back to arbitration, but sea carriage contracts is another common example of these international contracts which have application of international business law. Let's look at the third variety of international contracts for our particular example. Next slide, please. Insurance contracts. When you are purchasing goods and services, or you are building a plant in a different country. Let's say an Indian company is building a power plant in Rwanda, and the Indian company takes a contract of building a power plant in Kigali, Rwanda, but it also gets insurance that just in case there is some political turmoil or for some reason that investment goes to waste, it is also insured. Now, this may be a contract which may be subject to a joint venture between an Indian company and a Korean company to together construct a power plant in Kigali, in Rwanda, using technology from an American company, and it may be insured by a local company from Rwanda or from the African continent. Let's say a Ghana company is insuring that, or a company based in London is ensuring that overall project. You can understand that there is a wide variety of contracts, and each contract having their own set of applicable laws that are interacting in such a situation. And on top of that, let's say it's a nuclear power plant, it may also have other laws that apply. The international treaties uh, relating to nuclear energy, the local law of Rwanda relating to nuclear energy. And so the best way that we usually see in international contracts is, one, to keep all of these contracts separate, have all of these as separate contracts rather than have one master contract with 30 parties and 30 types of laws applying. For clarity, it's usually better to split them into clear individual contracts. Second, it's usually seen and a very efficient mode to have all of these contracts have a clear governing law clause and a jurisdiction clause. And third, in some situations, no matter how much you plan, you will also have a default application of laws. For instance, the default laws of Rwanda or the African Union or international law applying simply because you are engaging in a particular industry like nuclear power. So this gives rise to a very important area in law, which is called international contract management. Can we have the next slide? Now, international contract management is basically foreseeing what will happen in a transaction, planning and structuring a transaction, building structures properly in order to optimize the efficiency of your structures. For instance, in some situations, you can incorporate a company in a different country and get the advantages of the laws that that country offers for a larger transaction. Now, for instance, we act for a Singaporean company which is a subsidiary of an Indian company which is doing investments and trade in the region. The fact that it is incorporated in Singapore gives it access to a wide variety of other protectionist conventions, treaties, advantages that if it was just directly trading through the Indian entity, it may not have access to. And in the past, we see a lot of companies incorporating in favorable jurisdictions, which give access to a lot of international customs, international treaties and conventions, like Netherlands, or jurisdictions which are favorable for taxation, like UAE, Cayman Islands, British Virgin Islands, so on and so forth. So, incorporating companies in the right jurisdictions to maximize advantages is also one of the elements that we see in international contract management. We see structuring specific transactions, like we discussed specific contracts, structuring them carefully with clauses such as governing law clause and with jurisdiction or dispute resolution clauses, which tell you that in case you need to interpret this particular contract, you will interpret it using which law, or in case there is any issue, where will you go to sue the other side or to resolve the dispute. So, building clarity into the transactions already, and then staying compliant with applicable regulations of relevant countries. Sometimes, as we took the example of building a nuclear power plant in Rwanda, you will have to comply on a regular basis with all the rules and regulations that apply in that particular jurisdiction, where on ground actually the work is happening. Money may be moving from one place, employees may be going, technology transfer may be happening, but at the end, the plant is being constructed in Rwanda, and therefore, whatever laws or even pollution control laws, environment protection laws of that local area, they have to be complied with. So, international contract management also involves, planning this at a macro level and synchronizing this from an umbrella perspective with the help of a lot of colleagues. We do this sometimes for clients, and we do this from a macro perspective, but on ground, we very often end up taking help of a lot of colleagues from a local country, maybe in Ethiopia, maybe in Riyadh, maybe in Kuala Lumpur. And you see that local support very often is required, just because the laws of their countries say that only a local lawyer can do XYZ or advise on XYZ points. And in addition to complying with these rules, you also have to monitor, the updates to these laws. What if, okay, you were complied with the rules in 2024, but suddenly in 2025, there is a new set of rules that have come up. So you need to monitor those rules and the updates that keep coming to law, because law is a dynamic concept, and continue to comply with these. So international contract management is done at a very large scale in larger international transactions, where various facets of international business law that relate to a single transaction have to be managed in a unified, harmonized way. Okay. Now, we have spoken about a bunch of things so far. We've spoken about international business law generally. We've spoken about various types of contracts in which different elements of international business law apply. And we've also spoken about how to manage these at a macro level. Now, you must appreciate that international business law is a very wide subject. We, in fact, have various LLM programs on international business law which can barely scratch the surface. So, in this discussion, in a very short period of time, there is certain limitations on what I can cover in detail. But the objective has been to give you an overview of what is international business law. Now, one very important element of international business law is procedural law, because so far what we have been discussing has usually revolved around substantive law. I think all of you are clear between the distinction between substantive law and procedural law. Substantive law is things like your Contract Act, your Sale of Goods Act. Procedural law is things like your civil procedure or criminal procedure, the procedures which are used to give effect to the substantive obligations. So, very often, international contract management, international business law is revolving around substantive law. But what about procedural law? In such complicated transactions, especially in contracts relating to larger projects, larger transactions, millions of dollars at stake, sometimes even billions of dollars at stake, in that situation, it's very common to have disputes between parties. These contracts very often run into thousands of pages, with each section having, hundreds of other subsections, with interpretation, with various rules and obligations, with complex rules for waiver of rights and things like that. It is an incidental hazard that disputes will arise in a large number of these contracts and transactions. Dispute could simply be in relation to how much money is due, or what was the expected quality, or how should you release the deposit of a particular transaction. Very often we give a deposit in a transaction and the other party can raise a quality defect. So in such a situation, we resort to what is called international dispute resolution. Can we have the next slide as we discuss this topic? Now, international dispute resolution, as the name suggests, is resolving disputes of an international flavor. We saw a wide variety of international contracts, and in these contracts, the disputes that arise between parties are called, that dispute resolution mechanism generally is called international dispute resolution. Can be called by a variety of other names as well. But in a sense, it is resolving cross-border disputes. Yes, Sunil. Hi, Sunil. Sunil, do I understand correctly that you have a question?
Sunil, you can unmute yourself if you have any question. So I don't think so he has any question.
Okay, no, he's waiting for
Yes,
your
yes.
permission.
Yes, I'm able to.
Hi,
Thank you,
Sunil.
Gaurav.
Go ahead.
Hi, sorry to keep you waiting on this.
All right.
Okay, first of all, thank you so much for taking this session. As a compliment, you are very cohesive, very structured in your articulation, and of course, I would at least say about your SME skills. So definitely. So first of all, gratitude to you to train all of
Very
us.
kind of you.
So, just a quick introduction without delving into much details in this forum. I'm in-house counsel in one of the IT majors in Gurgaon. So, what I could understand, of course, I do understand there are limitations also, and it's a very introductory session. But you also delve into a few aspects of what are the overarching and holistic principles which guide major transactions. Now, focusing on the service contracts, where I mean, you delve into a very nice proposition, which we have also been following, where there is a overarching MSA between two group entities, and to facilitate harmonization of local principles, and at the ground level, where the contract would be ultimately executed, a separate local MSA is entered into between the entities. Now, in framing such contracts, can you, of course, the overarching principles are mentioned in the parent MSA, that the local countries, local MSA would provide for A, B, C, D, E, F, and accordingly, the local MSA is being entered into. Could you give us some scenarios or examples with your experience wherein in the local MSA, there are situations where a reference is mandatorily made to the parent MSA, which the local MSA effectively is unable to provide for. I'm not sure if I'm able to
No,
put across my query.
I'm not clear with the last part of your query.
Okay. So for example, let's say there is a parent MSA which says that the local MSA would provide for dispute resolution, the local MSA would provide for indemnification, the local MSA would provide for timelines of invoicing, payments, staff augmentation, etc. So then we refer to the local MSA language, which effectively is framed in line with the parent MSA. My query is this, that in framing the local MSA, have you come across some scenarios which in where areas in some area in the local MSA which mandatorily makes reference to the parent MSA and the parties are unable to provide for such scenario in the local MSA. So in such situations, the parent MSA itself has to be the governing law. Could you give some examples of any clauses or any permutations where local MSA mandatorily refer to the global parent MSA without providing for that in the local MSA?
Okay. So thank you, Sunil, for that question. Before, I start answering this question, let me just tell if anybody is still wondering what an MSA is, it's usually a master service agreement. Sunil, we're on the same page. We're talking about the same
Absolutely,
MSA,
sir. Absolutely, sir. Yes.
right? A master service agreement is generally an overarching umbrella contract. And very often it has what is called connected subsidiary contracts. These are contracts for provision of services of a particular kind. Now, Sunil, answering your particular question, I have in fact come across one of these situations where we had a two-tier mechanism with a larger master service agreement and a subsidiary service level agreement, where there were certain conflicts between the two of the obligations, and therefore this was a question in dispute that whether, to what extent do they overlap and to what extent you will use the governing law and the jurisdiction clause of one in another. How do you use clauses of one SLA in that case, which is a lower ground level MSA? How will you use that to... Sorry, my Siri is acting up. So how will you use that to interpret obligations in the other contract? But usually, if you look at practice, most of these contracts are structured in such a way that either they will be between different parties. That means on ground level, the entity, and here I'm not talking about the group, I'm talking about the specific entity, the specific subsidiary which is signing these contracts is very often different. And so these are separate relations. Or very often the subsidiary MSA will have other signatories on the local level. So it's not necessarily a bi-party agreement, it's a tripartite or a multi-party agreement. And second, in the event that the parties are same, very often you see that these contracts rely on what are called compatible jurisdictional clauses. That means the jurisdiction clause of the subsidiary contract is compatible with the jurisdiction clause of the master service agreement. And in those cases, we see very often, and I'm just taking an example, we see reference to a harmonized regime for dispute resolution. Both contracts very often will have saying that this will be governed by English law and this will be subject to SIAC rules. So in that situation, how do you involve various parties or various contracts in a particular dispute, you take it through what is called the joinder and consolidation mechanisms that are available in many international rules, SIAC rules, LCIA rules, so on and so forth. And in compatible clauses, you usually have a single harmonized system of law that applies, or even two separate compatible sets of laws like English law or Singapore law, English law or Indian law. So this enables you to harmoniously interpret both contracts, because if you can't do that, then because of confidentiality reasons, in some situations you can't even put the other contract in front of a different tribunal. And so the correct approach is to draft both of these contracts harmoniously. Sometimes we need to split it into two contracts. They need to be drafted harmoniously. They should have compatible clauses. That means clauses of one should be compatible with clause of another, and usually should be governed by the similar set of rules. Because if they're both governed by English law or both governed by Indian law, you will see that harmonious interpretation of the relationship between the subsidiary contract and the master contract becomes very easy. Does that address your concern? Do you have a follow-up to that?
I think yes, this very much addresses. All in all, I think the takeaway is that, of course, the MSA parent is entered into at first instance. So the takeaway here is that the local MSA, of course, has to be drafted and negotiated in a way that it doesn't surpass the governing principle of the parent MSA. Now,
One of the
just
things I've also found very useful is
yeah.
to keep it very clear, in the subsidiary MSA, just clearly stating that this is in furtherance of the master agreement that has already been agreed to between the parties. And in the master agreement, clearly adverting to the fact that parties will be conducting subsidiary agreements. Parties will be entering into subsidiary, what are called facilitation agreements, to ease
Hmm.
the process on ground. And as a claimant, very often we've seen situations where there has been a breach of multiple subsidiary agreements, and we want to go in a single proceeding. The respondent is taking the objection that these are separate contracts, and so they can all not be taken in a single dispute resolution mechanism. You can't have a single arbitration. You should have like 8 different arbitrations for 8 different subsidiary facilitation contracts. Now, a simpler way to get around that without a lot of argumentation, you can argue it, and usually you can still get it in your favor. But a simpler way is to just be more clear in both the MSA at the master level as well as the subsidiary facilitation agreements of the relation inter se between these two sets of contracts, and clearly establishing a hierarchical relationship that these are the subsidiary contracts that have been signed in furtherance of a main overarching master contract.
Yeah.
Do
If I
you have
can,
thoughts to add
yeah,
from your own experience here?
yes. No, no. So just maybe I can share just one bottleneck which I
Go ahead.
usually come across. So this, let's say there is a service contract and we are the contractor. Uh, so what happens is we sometimes find little challenge to convince the other party that hey, the of course, let's say there is a staff augmentation agreement, and so the entire, let's say, labor compliance onus is upon the contractor.
Yeah.
Absolutely okay. It's a given thing. We have to be bound by that. That's absolutely okay. And that's the iteration in the parent MSA also, that the service contractor at the local level would comply with the local labor laws. That is all right. No problem up till now. Now, there is a very specific aspect. There is a law which is known as Contract Labor Regulation Act, CLRA.
Yeah.
Now, if I need to engage subcontractor, or I need to engage my personnel, and the CLRA applicability triggers on, in that case, I need a particular form, which is Form 5 from the Indian entity of the group company. unless they provide me that, I won't be able to comply with the labor law in the second instance. And in this, we tell them that, hey, please, we develop a language where we say that you will also comply with your set of labor laws applicable to you. Now, this enters into a lot of heated negotiation. They say, hey, the parent contract simply says the entire onus upon you. Aap kuch bhi keh lijiye, the entire onus is upon you. To which we say, absolutely, we are not denying it at all. But unless you provide us the Form 5, we cannot comply, because what happens is they delay in providing Form 5, and then uh, due to a delay attributable to them, we end up delay in complying with our labor laws applicable to us. And this goes on for 3 sessions of negotiation until they actually realize, yes, until we provide them Form 5, they would not be able to comply with their own set of laws. So this is definitely a stretched language beyond the parent MSA. But yes, we do have a difficulty in convincing the other party, hey, this is critical for us to comply with the same, and any damages which as a resultant gets imposed upon us and but is attributable to you, we would not be able to bear indemnification for that. I don't I little if I complicate it too much, but that's actually
No,
the
maybe for a few others joining in, for me, I completely understand it. This is what we see on a day in, day out basis. What you're saying is something which is a very practical issue. I can see that you are dealing with these things very closely to be able to have such clear insights into this issue. Now, for the benefit of the rest of the class, if we don't go into the specific example that Sunil is sharing with us, if we just zoom out a bit, contracts are essentially risk attribution, risk appropriation mechanisms. So contracts are supposed to foresee what all risks can happen. And in such a situation, who is liable? Is it your problem or is it my problem? Because very often people, especially when you're dealing with a third party regulator, like in the example that was said, both parties are saying that's your headache, that's your headache. And it becomes a question of contractual interpretation. This is a problem that is hard to alleviate. No matter how much you foresee, there may still be a risk of certain obligations that were not foreseen or, were foreseen but are couched in a language that is hard to interpret one way or the other. And those very often end up becoming subject of disputes. One party will say that this was not my problem. I have an indemnity clause. So whatever money that I have been forced to spend on this, you are supposed to pay me back for that, because the contract says that all responsibility for compliance with labor law and things like that is one party's. It's not just in labor law, it could be environmental law. Let's say two joint venture agreement parties, in the example that we were taking, that an Indian and a Korean company are collectively building a power plant in Rwanda. If they improperly dispose of waste and pollute the environment of the place that they're building a project in that case, the government, rightly so, may come after that joint venture company for failing to comply. And then it becomes a dispute between the Indian company and the Korean company on whose liability was it to do the environmental cleanup. So these are complicated questions which very often arise in international contracts. And therefore, we have to go back to our first principles. Clarity is very important. Foreseeing these and already putting in clear clauses like governing law, jurisdiction, they all go a long way in keeping your contracts very clear. And in such a situation, we often end up, and I'm coming back to the topic that we are discussing right now, we end up using international dispute resolution mechanisms. Very often we see the use of first negotiation between both parties, Indian company, Korean company, CEO sitting down and negotiating, saying that, this was our understanding at the start. This is what our lawyers drafted, and this is what it says in the contract. Can we find a middle ground? Sometimes they get a mediator, they get a third party to facilitate their discussions and help them come to a common ground. And in some situations, they just cannot agree. And therefore, you see the use of arbitration. International arbitration today is the primary way in which international disputes are finally resolved, because Indian party doesn't want to go to Korean courts, Korean party doesn't want to come to Indian courts, and both the parties do not want to go to the courts of Rwanda. At least on the question of civil liability between the two parties, they don't want Rwanda courts to decide. So in such a situation, very often you see the employment of international dispute resolution mechanisms in the form of arbitration. One of the very commonly used mechanism in this part of the world is the Singapore International Arbitration Center. I don't know. These rules just became outdated 20 days ago. This is the previous edition of the rules. I'm still yet to receive my formal hard copy of the 2025 rules. But essentially, these offer a neutral dispute resolution mechanism. So the Singaporean and the Indian company can have their disputes resolved as per the rules of the Singapore International Arbitration Center. They can choose Singapore law to apply to the transaction, and they can have the dispute juridically, that is legally, seated in Singapore, so that nobody gets an unfair home ground advantage. At the same time, all of them get access to a neutral playground with fair and clear set of laws that apply to the transaction. And in the event that they have a dispute, it can finally be resolved through arbitrators. Arbitrators are decision makers that parties themselves appoint by contract, and the decision of arbitrators is generally considered final, binding, and without any appeal. Now, some of you may be thinking that, okay, Garv, it's all fine and good. Indian party, Korean party dispute relating to a Rwanda power plant. They decide, okay, we will resolve our dispute in Singapore under SIAC rules. There is a full arbitration. 1 year, the arbitration goes on. And finally, the arbitrators, 3 arbitrators consensus, they decide that as per the contractual interpretation, the liability for the environment cleanup was all on the Korean party. And therefore, any failure to comply with that, all the liability that has come, millions of dollars of fine or efforts in environmental cleanup, they are all the responsibility of the Korean party. And if the Indian party has spent any money on it, it is indemnified and it has to be reimbursed for that money. And the arbitrators say, okay, Korean party, give the Indian party $30 million. And the Korean party says, no. Fine, we've done the whole process. We've done the arbitration, but we don't like what you've said. So, no, you're not a court. You are not the court of my country. You're not my Supreme Court telling me that you have to do this. So, thanks for doing this, but no thanks. We are not going to give the other side 30 million. Now, this is where the beauty of the New York Convention comes in. In 1958, the New York Convention on the Recognition and Enforcement of International Arbitral Awards came into force. India was, in fact, one of the first 11 signatories of the New York Convention. And because of the New York Convention, which is one of the most successful conventions in human history, with I think over 150, 160 signatories, you can take that award of SIAC tribunal seated in Singapore and take it to any of the other 150 countries and have it enforced as a judgment of their courts. So I can take that award in Rwanda and take over, the assets of the Korean company that are there in Rwanda. I could also take it to New York, where the Korean company's banker holds deposits for them, or Switzerland, or Dubai, or any other major commercial city where they have any other deposits or any other securities, assets against which I can enforce a $30 million award. And I can also take that Singapore arbitration award to Korea and have the South Korean courts also enforce that arbitral awards as if it was a judgment of their own courts by virtue of the New York Convention, which was signed in 1958, which is completing 75 years and has been one of the most successful examples of international human cooperation that the world has ever seen. So, with this, I come towards the end of my presentation on international business law. We have primarily looked at substantive elements of it, what comprises of international business law, but we've also looked at some procedural and dispute resolution